Is everybody ready?
I'm ready.
Everybody's ready.
Action.
To all of our viewers out there.
How many people are watching? One. Your computer
It's
right
just
there.
her.
And Kurt and Aaron. 3.
I'm not actually watching.
Oh, good. Okay.
I'm
Thank
here.
you for
I'm
that.
here.
Good, yes,
Yeah.
you're real time.
Yes. All right. Let's see. Today is Monday, August 18th. Welcome. It's Monday, August 18th, 2025. This is the Board of Equalization and Review for Buncombe County, North Carolina. Call this to order. And per the North Carolina General Statutes of the Board of Equalization, must convene to hear appeals from property owners or their representatives. The duties of the board can be found in the North Carolina General Statutes 105-322. And I'd like to ask all cell phones be put on silent, please, especially yours.
I already did.
Yeah,
Is she busy?
I better make sure mine's on.
Oh my
I was
goodness.
gonna say, you need to be the boss of your own phone.
I know. You're right. You're right. It's, and it is. All right. Board members are myself, Randall Barnett, serving as the current chairperson. And I'll let each person introduce themselves.
I am Dr. Glenda Weinert.
Katarina Leager.
Preston Edwards.
Thank you for serving the county of Buncombe. Okay, minutes. We have the minutes from the last
Mhm.
meeting. Have y'all had a chance to look over those minutes?
Yes.
They're for July the 21st.
Yep.
All right. Do
Looks
I have a motion of approval?
I move that we approve the minutes as circulated.
All right. All those in favor? Aye.
Aye.
Aye. Because we don't need to do seconds anymore.
Mm-mm. Graduated.
Okay. Now, the big business we have today is we have an appeal. So
I think that's where,
I first asked, does any of the board members have a conflict of interest today?
No.
No. Yeah, I'm supposed to ask that. And we all say no. All right. So I'll call up the county rep.
So I will introduce the case. So we're in the hearing section, and it's the only one we have today, and it's John Feeney stolen property, 11 Hunting Lodge Drive, Black Mountain. And correct me if I'm wrong, it's Amanda Stearns?
Yeah.
It's their attorney, Stearns
Yeah.
here. And, oh gosh, I'm so sorry, Ann Stearns. And I'll pick up first Brian Marshall, residential appraiser supervisor, come up. Discuss the county side.
All right.
Where-
Brian in as well.
Yes. Just say testing.
I don't
Testing.
know either.
It's on.
Okay. All right. Mr. Marshall.
So,
Wait, Mr. Marshall.
yes,
Do you swear or affirm that the testimony you are giving in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Thank you.
And so I typically read these word for word, but you all have had a chance to look at the board book, and do you want me to need to read,
You can,
Everything in
you
there?
can paraphrase.
paraphrase?
Just
Okay.
get the gist for our audience that's
Okay.
watching online.
Okay. All right. So I'm Brian Marshall. I'm the residential appraiser supervisor for the assessor. This is a formal appeal for the property located at 11 Hunting Lodge Road, Black Mountain. The question presented here is the property correctly assessed for years 2024 back to 2020 in accordance with General Statutes 105-394? And can it retroactively adjust values and bill for years 2024 to 2024. Timeline of events, April 26, 2025, the property is listed for sale. May 7th, 2025, myself and Josh Houston, who I supervise, we reviewed the sales listing, and we determined that the property was substantially understated in comparison to the property record card, and it was determined that an immaterial irregularity would be issued for 2025 plus 5 years retroactive. May 9th, the material bills were mailed to John and Penny Stollery via certified mail. June 6th, attorney Anna Stearns filed a formal appeal via UPS overnight delivery on behalf of John and Penny Stollery for the property located at 11 Hunting Lodge Drive, Black Mountain, North Carolina, 28711. June 12th, the property transferred from John and Penny Stollery to Marvin and Donna Davis. All right, so the subject property consists of a one-story, single-family residential dwelling containing 1,196 square feet and a 541 square foot accessory dwelling unit. The property was listed for sale on 4/26/25 for $725,000 and closed on June 12th, 2025 for $750,000. On May 7th, 2025, Josh Houston reviewed the sales listing and made changes to the property for the current year back to 2020. Following changes were made to the property. Building one full bath added. Deck square footage changed from 108 square feet to 255 square feet, and the overall condition changed from normal, average, to renovated with an effective year built of 2010. An additional building was added. That was building 2 that was unlisted with 541 square feet of heated living area and 228 square feet of studio space, which is attached, and 164 square foot patio. This building was given a renovation condition and a year built of 1956 with an effective year built of 2010. A standard home site modifier of $10,000 was added to capture the value of the additional home site for the second building. Home site captures the value of grading, driveway, plumbing, and electrical, and so forth. The department position. As part of the due diligence for the formal appeal, the appraiser reviewed the sales transaction deed and prior listings and aerial map. Failure of the prior owners to properly list the improvements is a violation of General Statutes 105-285. So filing a permit is not considered reporting to the assessor's office. A notice, it's not an official value of any change. The assessor's office does review permit information when received and attempts to update properties accordingly. However, the burden is still on the property owner to ensure their property is listed correctly. I'm going to elaborate a little bit here. The assessor is responsible for creating an abstract or property record card for all real property in the county. The process, this process is referred to as a permanent listing system. Even in a permanent listing system, owners of real property in North Carolina remain responsible for listing buildings and other improvements valued at more than $100 that have been acquired, begun, erected, damaged, or destroyed every year. Given that the office did review the permit and failed to accurately update the code, update and code the property, it is a common practice to not apply the discovery process described in General Statutes 105-312, which incurs penalties. But instead, we utilize the immaterial irregularity process described in General Statutes 394, which does not apply compounding penalties. Again, listing errors do not invalidate the tax. In accordance with General Statutes 105-394, the property record card was updated and an immaterial irregularity was issued for tax years 2024 to 2020. All interested parties were charged with notice of taxes in accordance with General Statutes 105-348. Staff recommendation, after careful review of submitted materials and state statutes listed in the exhibits, it has been determined the county assessor followed proper procedure for listing, appraisal, and assessing the unreported improvements and subsequently issuing retroactive bills for tax years 2024 back to 2020. Therefore, the Buncombe County Real Property Appraiser staff does not recommend the board waive the taxes and interest due for tax years 2024 back to 2020. Again, listing errors do not invalidate the tax. Since the renovations were completed in 2015, the renovations should have been listed for 2016. But because we've adapted a year plus 5 timeline for immaterials, that means that the owners received a substantial tax break for years 2016 to 2019, in which the improvements were not listed properly. Also, the appellants, I guess we know the appellants are not the current owners of the property. That's all I've got.
Thank you.
Thank you.
First, any questions before he sits down?
Hold on, Miss, let's see, Mr. Do you have any questions for Brian that you would like to ask?
Just one, if I could.
Sure.
Were the property owners advised of the exact reasons that the valuations were changed? Were they given notice of what was improperly listed on their previous tax bills?
In the immaterial notice does not have those details. It has the, it's in our board book. That has the bills and interest. It's got the statutes and it's got that introduction letter in it. So were they, I don't think we send those, we don't send those out in the notice. The details of what was that, you're asking what was actually, were they
Communicated to the property owner?
Yeah,
Me answer anything?
I don't think so.
I'll have to get sworn in if I need to step
Okay.
in and answer anything. So,
All right.
I've got a question. I have a question, Brian.
Oh, yeah.
So y'all chose the immaterial irregularities
Yes.
over the other one. You had another,
Discovery.
yeah, the discovery, right?
Yes.
What was the reason for picking that over discovery?
Immaterials cover like listing errors that could be something that our staff missed. Okay, so they will, or actually that the owner failed to list during the listing period. I think that's actually that's what that means. It can cover either, I believe, and that's why we chose that over the discovery. Is more like used for, say, somebody builds a house or accessory dwelling unit, never got permits for it, never intended to notify us of any changes. That's a case where we would use the discovery statute.
Okay. So I think I know the difference between discovery and the
Yeah, and that
irregularity.
discovery does have penalties with it, so it's more severe.
Right.
I would say.
And this one doesn't have penalties. It's just pay the back taxes.
Yeah, we
and
just
any
asked
interest.
that, hey, you had these unlisted improvements, and we're just asking that you pay the difference in value for those unlisted improvements for those years, for this year plus however many years they existed going back, but no more than 5 years.
Right.
Plus interest.
Okay.
Yeah.
You have a question?
I do. So in the presentation of facts, it says, given that the office did review the permit and failed to accurately update the property, so it did come before you to be updated, correct?
It should have, although I saw some notes for like, there was like a plumbing permit, some stuff like that. We get those we get a monthly permit report from Black Mountain. And that comes through with about 50 or 60 permits every month. It can be anything from an HVAC change out to a new house. And so it's all we review those permits, and then we determine which ones are value changers that we need to follow up on or change for that year, and kind of track those for completion.
So these were determined not to add value, but we did go back and add value for tax purposes.
Yes. Well, there was some permit activity that came through, but we never saw the permit for the renovations, and it was primarily those renovations and that accessory dwelling unit.
Do you know why you didn't see the permit or who didn't send it to you?
Not exactly, no. And we looked for it, and they were there. But still, that burden falls on the taxpayer.
No, I
Yeah, okay.
understand that it
Yeah.
falls on, but
Yeah.
I also understand that when the permit, that the taxpayer is applying for permits
Yes.
correctly and
Yeah.
following the proper process, it was seen by the office
Yeah, likely it was. Yes,
and failed to update timely.
correct.
And now we're going to go back and back tax them because we didn't update properly.
Essentially.
Okay.
So permits can get missed for a number of reasons in my experience. So when those come through from Black Mountain permitting process, we look through those manually, and we have one person doing that right now, looking at each one. I think for July we had 60. And so he'll look through each one of those permits and determine which ones to create activities for those in our CAMA system. And those we'll start tracking, looking at those to see, like on a house, for example, a new house, we'll start watching the permit activity on that. And then at some point we go out and do a site visit and get measurements. If it's a remodel or something like that we can't really, maybe we can't go inside the house for, sometimes we'll call the owner to determine exactly what was done if there's not enough information on the permit application. But typically on that permit application, we're going to see a description of the project. We're going to get blueprints. We're going to get a cost estimate, number of bedrooms and bathrooms, square footage that's going to be affected, and so.
So after you discovered, I shouldn't probably use that word, after you
Yeah.
found
Yeah, we
on
discovered it. Yeah.
on May 7th, okay. You made a site visit soon after that?
Not on this one. We had sales listing information on it. So we had photographs, descriptions, everything that you would see like an MLS.
So y'all haven't made a site visit at all?
We typically don't do a site visit if we're confident in the information in the sales listing.
But you did actually find all of the permits for the changes that were done were on record
Yes.
for both the detached building and
There were.
all improvements were permitted properly.
It appears that they were, yeah.
Okay.
Yeah.
Anything else? All right. I think you want to be sworn in?
Yes. So I'll say one little thing, clarify one thing about
Well, I got to swear you in.
this.
Okay. All right. Eric, do you swear or affirm that the testimony you are giving in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God.
Real quick, I'm going to counter anything Brian Marshall says. I want to clarify one thing. This was from, correct me if I'm wrong, 2015, right?
That's
2015 permit?
correct. So it would have been listed for, we've gotten everything we need.
Time out.
Time,
Time out.
T.
Time
All right,
out.
that looks serious.
Let's- We can't have two people testifying
Same
at
time.
the same time.
Okay.
So,
I'll just say what I know
Eric,
about it.
you need to say what you need to say. If
Okay.
you need to recall Ryan and you want to ask him a question, you can do that.
Ah,
But you
gotcha.
can't testify and then, because.
All right. So,
Can I ask just a point of clarification,
Of
whether he
course.
has the authority to also call a witness, or is that in the purview of the chair? Call witnesses.
Yeah, since he is acting on behalf of the county as the county's representative, he would be, I'm trying to make this easy for you as opposed to have a bunch of random people come up and testify. So I want him, if he has some specific questions for Brian, he will ask those.
no, I don't, other than, I know the answer to that question, but I would want to just make one little statement here about the process, the permitting process. So this is a over 10-year-old permit that was pulled. We have it in our system now, but the permitting process isn't seen as listing your property. But there are issues with that. So there's things that can break in that process we may not get notified of. So there's all kinds of different components and mechanisms with the permitting process. So just because we pull a permit, I want to make it clear, it doesn't mean that it will always make it to us. Okay, so that's one of the issues we have. Not saying that's directly what happened in this case. This is an older permit that was pulled, but Brian laid out the how the flow from Black Mountain works. It's very manual, spreadsheet based. At the county, you pull a permit, it comes up as an alert in our system, and we see it usually. Now, sometimes that breaks. Same thing with the city of Asheville. Yes.
My only clarification is it does say they pulled it and reviewed it.
Yes. So I do.
So while it may break and be hidden somewhere.
Yeah.
They had it.
Yeah, you can pull it up. There's some things stated earlier saying that pulled a permit that, hey, we've done what we should do. Not necessarily true. It's not considered to be reporting to the assessment office. Even if you pull it and we review it, still not considered reporting. So that's all.
And
Are there any other
a
questions?
permit could be pulled and they never get around doing the work. And then the
Exactly.
permit
And when we-
expires and work's not ever done.
Yeah, when we do see those, we do check in on that when we see them. We see the vast majority of them, just about all of them. I can comfortably say we receive 99.9% of the permits pulled. But now, we had a different camera system as well in 2015. We don't have the updated system we have now. So that's one of the issues there. So it's been a long time. Any other questions? That's all I wanted to say.
Miss Stearns, do you have any questions for Mr. Kreger?
I don't.
Great. Sorry.
So does Mr. Marshall need to clarify anything? Because the question was asked to you before.
Or
and
do you
you-
want him to come back?
I think that the county can recall him after
Okay,
Ms. Stearns does her presentation. Since Ms. Stearns is an attorney, you do not need to swear her in because she is not testifying as a witness.
oh, good. Okay, you're good to go there.
Thank you. Anna Stearns for John and Penny Stollery. As was noted, just as a point of clarification about standing, Mr. and Mrs. Stollery did sell this property in June of this year, but under agreements with the current property owner, they are still responsible for the payment of any taxes for the years 2020 through 2024 in the event this appeal is not successful. So as the property owner at the time and under a standard North Carolina real estate contract, they're responsible for any taxes for prior years. I want to just start by saying we certainly do not contest the tax assessor's authority to revisit, reappraise, or revalue properties once they learn that there is some new information that was not properly valued or listed for any reason previously. There are a lot of structures in Buncombe County, and that's a daunting task. And when they have information available to correct their record, we certainly want to encourage that to happen. The notice in this instance cited the immaterial irregularity statute, but quotes language recited in the discovery statute. which Mr. Marshall has stated just now is not the basis of the discovery tax bills that were issued in this matter. Those are being issued only under the immaterial irregularity statute. That's what's cited in the notice to the property owners. That immaterial irregularity statute allows for the collection of up to 5 years of taxes for prior years. I think it's helpful to consider the framework of those 3 statutes that address the ability of the tax assessor to adjust values, both for listing errors, and clerical errors, or for simply not properly listing a structure or acreage at all. The first is the immaterial irregularity statute, which is what is cited in the notice to these taxpayers. It provides that immaterial irregularities in the listing, appraisal, or assessment of property for taxation or in the levy or collection shall not invalidate the tax imposed. The statute goes on to provide for a list of examples of things that fall under this statute as immaterial irregularities, including the failure of an officer to take an oath, the failure of this board to meet timely, the omission of a dollar mark on the tax bill, and defects in the description of the property listed. The statute is not intended to cover situations where the county failed to properly value the improvements based on information already in its possession. But rather, the statute is intended to ensure that the county does not forfeit otherwise properly assessed taxes simply due to a clerical or administrative error. Likewise, the discovered property statute, which is section 105.312, is intended to apply to situations in which real property or structures not previously taxed are considered discovered, found, newly appraised. This is apparent by a reading of subsection F of that statute, which provides the taxpayer with an opportunity to prove that the property was not in existence in prior years, that it was actually listed for taxation, or that it was not his duty to list it. There is, however, no similar opportunity for the taxpayer to evaluate a newly issued appraisal for property under this discovery statute. That is because it falls outside the intended use and scope of that statute. The third statute, the one that we believe is most applicable here, allows for changes in the appraised value of property in a non-appraisal year, a year in which a general countywide reappraisal is not occurring. That statute is section 105-287. It provides that the assessor may correct a clerical or mathematical error, recognize an increase or decrease in the property's value resulting from physical changes to the land or improvements, or otherwise recognize an increase or decrease in the value resulting from a factor other than one listed in this subsection. The difference between that statute and the statute relied upon by the tax assessor is that section 287 allows only a prospective change in the assessed value. It does not allow for the collection of taxes for the prior 5 years, as does the immaterial irregularity or discovery bill section. I'm going to pause, Mr. Barnett. You had your hand up.
Yes. Is there a title, a name for the 287?
Yes, sir. It is changing appraised value of real property in years in which general reappraisal is not made.
A long title.
It is a long title.
Okay.
So the county's position, as we understand it, and I believe as Mr. Marshall has stated this afternoon, is that it only recently became aware of the improvements to Mr. and Mrs. Stollery's property through their MLS listing of the property for sale. This is an important tool, and we do not begrudge the tax assessor the ability to rely on those tax listings to discover instances in which the value of a property may not be accurately reflected in the current property card. These improvements, though, included a remodel of Mr. and Mrs. Stollery's primary residence in 2011 and the renovation of the accessory dwelling unit in 2003. This has been characterized by the county as a missing data point, capable of correction through this immaterial irregularity statute. But as has been noted, Mr. and Mrs. Stollery pulled the required building permits, and we have verified with the town of Black Mountain, and indeed the county has admitted this afternoon that those permits were received by the county. Mr. and Mrs. Stollery did not conceal the improvements. There was no misrepresentation or omission. The improvements were fully visible, legally documented, and filed with the county at the time the work was performed. And in each subsequent year, those same improvements appeared on the tax listing for the property as far as Mr. and Mrs. Stollery were informed. To the extent that they were not properly valued by the county, the appropriate remedy is correction of that value under Section 287, which, as I have just previously stated, does not allow for retroactive application of that value. This has also been upheld by the North Carolina Court of Appeals in a case titled Henry Pace/Dowd Properties Limited, in which the Court of Appeals rejected exactly this misapplication of the immaterial irregularities and discovery bill statutes in an instance where the value of a property simply needed to be adjusted in a non-general appraisal year. The court emphasized that the immaterial irregularity and discovery statutes cannot be used to correct an assessor's delayed realization of previously available facts. And that's exactly what's happening here. You have affidavits from Mr. and Ms. Stollery and from Jennifer Tipton, the permit clerk in the town of Black Mountain, attesting that these permits were provided to the county. To allow a 5-year retroactive assessment under these circumstances would be to turn this discovery statute scheme on its head. It would allow for an administrative backfill and reduce taxpayers' ability to rely on the accuracy of bills already issued. The reading ignores the carefully designed structure of these statutes, which provides separate processes for correction of incorrect taxation resulting from administrative errors under the immaterial irregularity statute, the complete failure to list property or improvements under the discovery statute, or the failure to properly assess changes in value resulting from improvements to property under Section 287, which is what we believe is the most appropriately applicable statute in this situation. We respectfully ask the county to rescind the retroactive discovery bills for tax years 2020 through 2024. And if the county believes that a value adjustment is warranted, that it proceed in accordance with Section 287 on a prospective basis only. Happy to answer any questions.
I was wondering if the Davises knew about this before they purchased.
Yes, sir.
They did know.
Yes, sir.
And they knew that you were hired to take care of it.
Yes, sir.
Even so, but you're the your clients are the Stokeleys.
Stollery's, yes.
Sorry.
That's yes.
The sellers. Yeah, the sellers
Yes.
are your clients. And the sellers are paying for you and not the Davises.
That's correct.
Okay.
May I ask a question for clarification? So in how you were notified or the client was notified, it included both portions of discovery and irregularity in the same reasoning behind the back taxes. Did I understand
Yes,
that
the
correctly?
notice itself only cites the immaterial irregularity statute, but it quotes language from the discovery bill statute,
Okay.
leading us to believe that those two were being read in conjunction together, providing a much more expansive interpretation of the statute than I believe was intended by the General Assembly in developing this scheme.
And clarifying that under 287, the valuation is only moving forward, not retroactively, but the discovery, I don't know the right word, but the discovery statute is allowed to go retroactively.
That's absolutely correct. And the reasoning behind that, if you kind of look to the purpose and intent of that statute, is that if a piece of property is newly discovered by the assessor, one can logically assume that it existed for each of the previous 5 tax years, because the dirt is the dirt, right? It didn't just spring out of nothingness. And so the statute allows for that discovered property to be taxed for those previous tax years.
Right.
But when the value is changed, that statute section specifically says that that change should only be applied prospectively.
Okay.
And then the assessment going forward is because there's a new value that's been determined, and the tax will be based on the new value
That
from the year going forward.
That is my reading of the statute, yes.
Okay.
How involved are the Davises at all? Are they willing to pay?
Anxiously awaiting the outcome of this
Okay.
hearing.
Are they willing to help out in
But-
any payment or anything?
No.
I'm still hung up a little bit. You clarified this a little bit, Eric, but the difference between and this might not be a question for you, but sounds like the permitting process has one track and the tax valuation has a separate track, and they overlap, but they're not, the permitting does not,
Ms. Slager, if I may.
yeah.
To help you out with this, I
Thank
think
you.
No, I see where you're going. I think the legal question that you all have to be determining, and this is one that there's not really any case law on, is whether the application of a permit, when you apply for a permit with the county, is that somehow also notice to the tax assessor's office? Because you remember that there is a statute that says that every property owner in the county is responsible for notifying the tax assessor's office of any changes in property. And so I think where the immaterial irregularity or something for you to consider is discovery is more where there is intentional. It's a willful omission, shall we say, of not reporting your change in your property. Whereas an immaterial irregularity can be seen as a mistake on the county's part. And I think I would refer you to 105-394 subparagraph 3 that talks about the failure to list, appraise, or assess any property for taxation or to levy any tax within the time prescribed by law.
That's what I was reading.
And I think our argument would be that there has been no failure to list
Right.
or appraise. It is simply that it was not appraised at the value that the county has now determined is correct. And so the more appropriate statute to apply in that situation is the change in value statute, a statute specifically intended to address that situation. I would also note that the property has been through at least 3 general countywide reappraisals since the time that the remodel was done in 2011. And at no point were they given a new value for that or had any reason to believe that the value listed and appraised was not correct.
But the homeowner at that time, your client, didn't inform the tax assessor's office of the changes.
They had already been informed through that permitting process
The permitting
and believed
process is
that
there.
their tax listing was correct.
But
Well,
you're
and
saying
here's-
that the permits don't automatically
Right. I
inform
think
the
that's
tax.
that's
where I'm hung up.
That's where the question ultimately, I think that's the $50,000 question, or at least one of those, is whether or not that is, because once again, people apply for permits all the time and they don't necessarily follow through. There's a lot of things. There's arguments both ways.
Yeah, of
And I
course.
think that that's something that you all, and I don't think I think that if there was a case out there, a magic bullet to end this, either she or the county would be providing you with that case. So I do
Yeah.
think that this is a matter of impression and something that you need to think about. What is the best policy for the county moving forward, subject to an appeal to the Property Tax Commission or the Court of Appeals.
Well, it appears to me that there's a series of events that have occurred. If the homeowners had not submitted a permit, then there would not be information. The county stated that they did see the permit. So the homeowner should have notified the assessor's office, but the county should have too once they saw the permit, and they didn't either. They don't. The permit is not necessarily notification
Right.
because they may or may not see it, but they did see it. And the property was appraised 3 separate times with no additional increase in the value, even following the improvements. So then once it listed and sold for more, then the county went back and assessed more tax based on the new selling price, which is the statute of 287 that she's referring back to.
But is it the permitting office, is it their responsibility to notify the tax office?
It's not, to me, it's not about the permitting office responsibility.
Right.
The county knew. The county knew and didn't do anything.
Yeah.
It says they didn't.
And the county chose to use the immaterial irregularities instead of the discovery.
Instead of
Well, they had
287.
3 choices.
Yeah.
Three choices, and they chose the middle choice. And
So here's something I want you all to consider, and I think Ms. Stearns and I both agree on this point. Correct me if I'm wrong. We
Exactly.
discussed this beforehand, but you have one issue is to determine whether or not what happened constitutes a material irregularity. If you decide to find that it is a material irregularity, then it cannot be appealed. Okay, so if you find that it's a material irregularity, the appeal ends because we are allowed to go back and correct those under the statute. The other argument is that this is not a material irregularity, and that it is a change in value. And if so, if it is a change in value, it is properly then before the Board of Equalization and Review for you to determine whether that change in valuation is appropriate under the statutes. Does that help clarify? Those are your two issues, because if a material irregularity is not appealable in a
And I
sense.
just want to clarify what I think is just a misnomer, but it's immaterial.
Immaterial. I'm sorry.
Regularity.
I'm saying immaterial.
Versus
Immaterial.
material.
All right. Sorry.
Sorry.
My dyslexic brain sometimes, but nonetheless.
A distinction. but-
So if we determine that it is not an immaterial irregularity, then we can move forward with a decision outside of that. If we determine that it is that, it's ended and comes back to the county for
Well,
further.
if you decide that it's an immaterial irregularity, I do not think that you can void the back taxes.
Okay.
Okay, but I think that the issue is still open as to whether or not you can waive the interest that has accrued on that money, because that could be considered a penalty or something to that extent.
that's what I was.
But once again, if you decide that I don't think that you have the ability to waive the back taxes on an immaterial irregularity.
Right.
Does that,
But if we say it's not that, and we say it is a changing
if it's
value
a,
statute,
if it's a change in value and things like that, then you are looking at whether the county followed the appropriate procedures in changing that value. And whether they can go back for the past 3 or 4 years. Yes.
does that statute give the county permission to go back 5 years?
I do not think that if it is a change, most of the time when you see a change in value, it happens in at the beginning of the tax year. Basically, all property owners are required to list any changes in values within 30 days from January 1st through January 30th. You have 30 days to notify them of a change in value.
So the statute actually provides that an increase or decrease in the appraised value, which can be made at any point during the year when the assessor
into
discovers some reason for a change, that increase is effective as of January 1st of the year in which it is made and is not retroactive. That's the language of the statute. I think one of the difficulties is that the immaterial irregularities statute is actually pretty short. It says that if there is a problem with the listing, appraisal, or assessment of property for something like this list of reasons that are given not as an exclusive list, but as examples, that does not invalidate the tax that has been previously assessed. And the case law that's interpreted this section of the statute seems to make clear that that is used to prevent property owners from challenging their tax bills and saying, well, you said it was 12 Hunting Lodge Drive, not 11 Hunting Lodge Drive. And therefore, I am not going to pay the tax bill because you incorrectly listed it. That would be an immaterial irregularity. The property is still there. The house still exists. The fact that there's a typo in the number of the house is not what creates a lack of liability of the property owner. But in order to reach the provisions of the statute that allow for the 5-year retroactive collection of taxes, you have to reach into the discovered property tax section, which is section 312. That's the section of the statute that allows for up to 5 years of retroactive taxes to be collected. The tax assessor is not relying on the discovered property statute here, only on the immaterial irregularity statute, which does not provide for the collection of retroactive taxes, which leaves us with section 287, the change in value statute, which can be prospective. And again, no fault with the tax assessor taking the MLS listings and determining whether properties have been properly assessed for their value. We just believe that both for a public policy and a fairness reason, that should be prospective only.
And according to the statute of changing appraisal value statute, it's only for that.
That's
It's just
correct.
for changing only and not
Well, and
going forward.
I have a thought, maybe to be directed to the county. Since permitting is not seen as notification to the assessor's office, that when an individual comes in to apply for a permit, that an additional step be added, that they must notify the assessor's office of their intent to improve or change or build on their property, that is a requirement. Because I would dare say that most taxpayers know about permitting, but don't know that they are required by statute to notify the assessor. So as operators of our county, and in being fair to our constituents and the folks that we're looking to protect, we need to make sure that they're notified properly. Because I don't believe that that's a generally known fact, even though it is a provable requirement.
That's a great point, and I'm sure that we can bring that up and put some sort of, I guess, warning language in the permit and when you're applying for a permit or something like that. I don't think that would be that difficult at all.
Okay.
But thank you.
That would be something for our commissioners to do.
Back to-
That would be something our commissioners would approve and make that policy change.
Or
Well,
I think the
that
county
probably could be
office
done
can,
at
the
the
tax
staff
office
at
can.
the staff level. So
Staff level.
yeah,
So-
we just need to amend some forms. But I hear the point that's being made.
Any other questions I can answer for you?
Let me see. I think there was put notes on so many different places. When I saw something, I had a question.
I think just as a final matter, I did not give you the subsection of the statute that I was reading from. So that's subparagraph C of section 105-287. Thank you for your time.
Thank you.
Thank you.
A dense topic.
I'm it's fascinating, actually.
Okay.
I was coached on the two discoveries and the immaterial irregularities, and have come out of this hearing learning of a third, the changing value statute, which
That's typically lean on that when we're describing,
Your light's not-
oh, light needs to be on. We typically lean on that when we're describing reported changes, folks reporting their tax listings to us, updates to their property. And yes, when we receive those permits, we that's the statute we refer to in that. So moving from got built an addition onto my home is from this point forward using the previous reappraisal schedule of values. One thing I'll add to these is on these immaterials and on discoveries, we do go back, say we go back to the last 2021 reappraisal, and we also review the 2017 reappraisal schedule of values to get that 2020 valuation in there too. So we are adhering to the value as if that structure was there, that valuation method applied to the relevant reappraisal. So a lot of words there, but that's saying that we are treating it the same as any other property that would have been relevant to that reappraisal. Does that make sense?
May I just restate my understanding, please? It appears to me that the previous owner, permitted properly, thought that the permits were sent from Black Mountain to the county, which was confirmed. So therefore thought had notified properly or had done the proper process to do this. On top of that, there were appraisals done between assessments between 2020 and 2025.
2013, 2017, and 2021.
Okay.
For the three general reasons.
Okay. And so that was inside the 2020 to 2025 time period.
They were reappraised the property was reappraised as part of a countywide general reappraisal
In 20,
3 times between when the most recent remodel occurred and the tax year, the current tax year.
Okay.
So not that it was reappraised during that 5-year period of the back
Okay.
taxes necessarily, but that the county has thrice had the opportunity
To
adjust the value.
okay. So I think that's what I was trying to say, but not, okay. So they've had time to reassess the value of the property. And on top of that, it appears to me that the change in value or the MLS listing or the sale is what notified the county. And then they went back when they could have done it, when the permitting was done and valued it at that point in time. So it appears to me that it's a change in value based on the statute. I don't get the immaterial irregularity at this point. And then the discovery statute was used in the notice sent, which doesn't appear.
They mixed them.
It's all kind of mixed together, it appears to me.
That is our
And that it's, the only thing to fall back on is that the property owners should have notified the assessor's office, but in getting permits and the permits going to the county identified that they were notified. So that's kind of where I sit.
Right. So, any statements on this side? Where I'm hanging my hat on the decision that I'm probably going to put forward is the assessments 3 times since. So there were 3 chances to do it, and the mixing of the 2 statutes together.
I want to make one statement about the reappraisal
Yes.
and the permit. So,
And they did adjust. I see the 2020.
Yeah.
Adjusted.
So once a permit's pulled and completed and reviewed by our team, each time we do a reappraisal, even if we reappraisal 3-4 more times, we wouldn't go back and look at those historically closed permits. You know, the assumption.
I don't
And-
think that argument has been made, that there was any requirement that be done or that
Right. I
would
think,
result in a change in value.
yeah, I think the
Not-
fact that we've
not
had
sure that
2.
Additional argument is appropriate right now while the board is deliberating.
I don't think they've closed the public or the hearing portion of the
No,
of the hearing yet.
we haven't made a motion.
But also did not ask a clarifying question or ask the witness to come back up to testify. That was offered spontaneously.
We're a little informal. Would you like the county to step up and present a rebuttal case?
I don't think that's necessary, but I do get the sense that the county feels that the arguments are not going in their direction and would like to offer clarification at this point simply for that reason.
Well, that would be up to the chair as to whether they want to consider that or not.
So it's not appropriate.
I think we should bring him back up.
Nope.
I feel like if the county has clarification to add that,
But it's not clarification.
okay,
It's explanation of why they didn't share.
can I ask that clarifying question?
Not
Not now.
not now.
Well, let's say if you all want to close the hearing portion and then you can move into deliberations, then asking that normally there's no more presentation of evidence or witness testimony or anything like that.
Yeah.
So I think that would be the first thing that you may want to decide whether you're
Okay.
ready to move into that or not.
I am.
I'm ready to move into the
I am.
deliberation.
Yes, I am also ready to move into
So we'll
deliberation.
close the,
Close the comments and testimony.
right, and now we make a decision.
But then we have to have a motion to close.
I think so.
All right, do we hear a motion to close? The
So
deliberation.
moved, please.
Okay, all those in favor?
Aye.
Okay, now we need a
So now we,
motion on deliberate, a motion. We need a motion and deliberate that.
I make a motion that, following the testimony of both sides of the items, that we move to use statute 287 to move forward with this as evaluation and decide based on those facts.
All those who deliberate on this, because we don't need a second. So now we're going to deliberate.
No, but just to make
The
sure that
motion.
you all are clear, in order for the motion to pass, 3 of you need to vote in favor of it. So if it's a 2-2 tie, the motion fails.
But we made the motion so we can now deliberate.
Yes,
Yes.
I just wanted to make sure that you all were clear that it needed to be a majority.
Ooh. It's true.
right, and we're missing our.
Yeah,
our
we usually have
person.
five members. Okay. Well, I was planning on, when, pre-seeing this, I was planning on letting them off with no interest, but paying the back taxes.
But you
'Cause-
can't
'cause
under
I-
discovery.
Right, because,
Right.
so I considered that. But now I'm shifting to the way the motion was stated, which would negate that. It would take it all off.
Yep.
And the reasoning is that the mixing of discovery and the other statute, the immaterial, irregularities, yeah,
Yep.
Immaterial.
being mixed together.
And it could just be something I'm missing, but I'm not seeing how it's an immaterial irregularity
I don't see it.
and how I'm understanding what that is.
I don't,
I
think
wonder
I'm in
why the
agreement with
county
Linda.
didn't use the discovery statute.
I asked that question.
Yeah. No, but I just mean if the intention is to collect the 5 years back taxes, and that's not,
Well, Discovery would have had a penalty fee,
right,
and the one that they went with just has an interest.
but I agree. I don't see the irregularity, immaterial irregularity, and that's why. And then when you put the discovery information in your notification, which is not what you're alleging, then that creates an irregularity, and then leads us to the 287 statute. which I think going forward, it should be properly applied.
Other deliberating thing, or are we ready to call a question?
I make a motion to call the question.
We vote on calling the question and then vote on the.
Yep.
All right, all those in favor? On the question?
Aye.
Aye. All right, now, can you restate your motion?
The motion is to move forward with, follow that, in light of the facts stated, that there is not immaterial
Regularity.
irregularity.
That's a hard word.
That discovery was mixed in with the notification under that statute. Therefore, in this hearing, we have determined that it falls under the statute 287 for valuation moving forward.
All those in favor? Say aye. Raise your hand.
Aye.
Aye.
You have to raise our hand. All those opposed?
Aye.
3-2.
3 to
3-1,
1.
excuse me.
So the relief for the taxpayer has been approved. Okay. We will,
All right.
That's,
I default to the staff recommendation.
that was the only case we had
I
today.
think that's it on the agenda.
We're free to adjourn, so.
Oh,
All right, I make a motion to adjourn.
all those in favor of adjourning, say aye.
Aye.
Okay.
Thank you very much for your time and consideration.
Yes.
It's a tricky issue. And,
It was tricky, but you explained